The items which have been called yesterday, those will be called today.
My lord,
Okay.
only confusion
Am I
was
clear?
yes, my lord.
Much
But
again.
only confusion is after 46, my item is 77 and 78. Those have been kept as 1 and 2 today.
Yesterday's cause.
Yes,
Actually,
yes, it
yesterday's cause
is.
list.
Yes, my lord. It
Now,
has been kept as 1, 2 today. Item number 1, 2 in today's list, which is why I was wondering. If your lordship looks at today's list, it is item number 1 and 2 today as kept as to be mentioned. It was 77 and 78 yesterday.
item number 77 and 78.
Yes, my lord. Yesterday's list. My lord, I was here till 4:30. I was here. একটা নিউ ইন্ডিয়া অ্যাসুরেন্স বলে একটা ম্যাটার আছে দেখো, it's kept as to be mentioned today 1 and 2.
You are for the
I'm for the plaintiff defendant petitions.
dependent
Petitioners here.
petitioner herein. Who is for the
No, this is the first time, my lord. It's a motion stage.
from the advocate for the petition hearing of the matter stands at John. Yes. What is the issue?
None. My lord, kindly come to the, my lord, here the suit was filed. My lord, the plaintiffs, my lord, filed the suit, my lord, for declaration, injunction, giving this petitioner in respect of certain properties mentioned in, my lord, constitutional property, claim. Now, my lord,
First of all, what is the impugned order?
impugned order, my lord, kindly come to order dated 41, dated 4/10/2024.
Yes. What was the petition? What was the prayer in the petition?
My lord.
Amendment of the written statement, seeking amendment of the written statement.
Yes, they are rejecting the application under order 617. My lord, here what has happened, my lord, the person, my lord, who is being the plaintiff has filed, my lord, the suit, my lord, the Pontai Thana Primary Teachers Cooperative Society. We took the plea, my lord, that there is no existence of this society.
So the amendment sought for has been made at a belated stage after
My lord has
deposition of DW3.
yes, my lord has found that order.
Yes. Second last page of the record.
Yes, yes. Today is fixed for passing of the order in respect of petition dated 1/8/2024. I had heard the learner such and such. It appears from the petition of the
On careful perusal of the record, it appears that evidence on behalf of the plaintiffs was adduced long ago on 5/3/2021, and till date, three defendants witnesses have been adduced.
Kindly see the fourth paragraph of that order, madam. It appears from the petition of defendant number 3 and 5 that they intend to incorporate certain statements in para 16 of the written statement, stating that there are no office bearers of the plaintiff society since long time. The plaintiff was appointed as board of administrator on 30th/11.
Learned counsel, what is wrong?
My lord, I'm coming. On basis of which the plaintiff was appointed as inspector of cooperative society, chairman, manager, Mugrai Central Cooperative Society, and the plaintiffs have had no locus standi to file the instant suit. The plaintiff in his written objection has vehemently objected to the statement made by the defendant number 3 and 5 in their petition and has prayed for rejection of the same. On careful perusal of the record, it appears that the evidence on behalf of the plaintiffs was adduced long back in the year 5/3/2021, and till date their defendants witnesses have been adduced so far. And ultimate stage, such a petition has been filed by the defendants and already commenced, and I see no further reason as to why the issue could not be raised long before trial. Moreover, the instant petition shall not assist in any manner in proper adjudication of suit, but on the contrary give rise to severe complications. In view, I find no impediment to reject the petition dated. Now, my case is this, my lord, that after filing of the suit, the plaintiff in the deposition of DW, kindly come to the deposition of DW3, man, who is the assistant registrar of cooperative society.
Page number?
Page number, my lord, will get it from page number 37. The I have bought the original copy of the order dated 3/11/2007 passed by the Office of the Assistant Registrar of Cooperative Society and an attested copy of the same. I am the incumbent custodian of the said order. Then, my lord, it is a fact that I have received summon and deposed as witnesses on earlier occasions from this court. In summon, I was not asked to bring any document. I have bought the register of official orders today. Now, I cannot say whether there was a secretary, president, and board of administration before and after passing of the order number 6364.
What do you intend to incorporate?
I want
Was
to,
it not in your knowledge?
yes, that was not it, because after this deposition, my lord, I came to the knowledge of DW3.
Then notice has to be issued.
Hello?
Notice has to be issued.
And my lord, I will be staying, paying for stay of this truth, my lord.
No, learned counsel. Noted. Notice, okay, the learned counsel representing the petitioners. They can even. Petitioner submits that after the deposition of the DW3, it has come to the knowledge of the petitioner's defendants about the fact which are required to be incorporated. As such, the application and Order 6 Rule 7, Order 6 Rule 17 of the Code of Civil Procedure was filed. So, ultimately, the said application has been rejected. This court is of the view that the presence of the opposite parties are required in such circumstance. Issue notice upon the opposite parties that the matter appear after 1 week of the puja vacation, subject to the convenience of the court on the bench.
Let us short stay with this. Because, my lord, kindly see the prayer, my lord, in my amendment petition. But otherwise, this application will become unpurchased. If it is
No, Lordship.
the
No, not at all, not at all.
let it appear after 2 weeks, no? After 1 week after vacation, my lord, we have to serve.
Yes.
On the opening.
4 weeks vacation.
Yes, in vacation, my lord, no one will come and my lord.
In the 2 weeks for
My lord. Deep breath.
গেটটা কত হলো? Learned counsel. On this one.
My lord, 22 after vacation, my lord.
Next.
21, Lordship, 21 kindly after vacation, Your Lordship.
Next.
24th ta डालना हाँ Lordship 24 I appear for the petitioner. It's coming for the first time. Lordship, here the order that is impugned with your Lordship is where the opposite party's application under section 10 was allowed. Lordship will just kindly see the impugned order.
Res sub judice.
Yes. I'll tell your Lordship what are the two suits. Just kindly bears with me before I.
Plaints.
Both the plaints are there.
Which one is the first one?
Lordship, first one is the opposite party's plaint.
Page.
That plaint is page 62. January 2019.
Money suit 31
Money
2019.
Money suit. Yes.
What was the prayer?
My lord will kindly see the prayer.
And the second plaint?
Prayer is
Second-
page 66.
Second plaint? Second plaint?
Second plaint is page 22.
22.
It's an interpleader suit, my lords.
Hmm.
Lordships are aware, interpleader suits are not the regular suits that we file. Lordship, in this suit, if you Lordship sees page 22, I have stated that Lordship kindly takes up page 47. I say that defendant
Learned
number.
counsel, who are the
Yes. It is
defendants?
Lordship.
Defendant
Defendant
in
number
your plaint. Defendants in your plaint were their parties in the earlier
Defendant-
suit.
Defendant number 64 in the suit that I'm showing to your Lordship, page 33. Neeta Agarwal.
What about 1 to 63?
Lordship, that's what. The interpleader suit, the transaction that I have pleaded in my suit, my lords, is that defendant number 150 owed me money and defendant numbers 100 to 149 had given me money so that I could complete a business transaction, and when the money would be received,
Issue notice.
Lordship will issue.
Same order. Details is upon the respondent opposite parties.
Only one. It's only one. I'm grateful.
2 weeks after vacation.
I'm grateful. Miss.
Yes. 26. 27. Number 28. That's it.
Hello, for I appear for the petitioner, my lord. This is my matter, my lord. This is related to. This is my revision application, my lord, from the order passed by the learned below court, my lord, dismissing my order 7, rule 11 application, my lord.
Why you sought for rejection?
My lord, what has happened? I'll tell you in the story, the facts in brief, my lord. I am the tenant in a property where the landlord has filed a suit against me for recovery of possession, damages, and what he has done, he has combined two different agreement, two different premises in a single notice to quit. And he had asked me to vacate that and suppressing all the
On the
facts
ground, recovery of possession on the ground,
on the, my lord,
recovery of possession.
on the
On-
grounds of additional alteration and additional alteration
additional
and
alteration.
subletting, which is in the agreement. I'm allowed to do it. I will show you lots of the agreement also. There are two, there's one ground floor and one mezzanine floor. My lord, may kindly come to my WS1 because all this thing has been suppressed by them, my lord. If you see page number 84, my lord, the ground floor unit, that is unit 1, my lord,
Wherein you have filed order 7 rule 11, wherein
before the learned court below, my lord, in the Alipur court,
in the suit,
in the suit, my lord,
in the suit,
my lord, in the eviction suit, my lord.
in
I
which
have filed-
eviction suit? In which eviction
My
suit?
lord, this is ejectment suit, sorry, my lord. Ejectment suit 41 of
Whatever it may be,
2000.
eviction suit, ejectment.
That is
suit,
at page
whatever.
19, my lord. Ejectment suit number 41 of 2022. What the landlord has done, he has tried to
Defendant, by filing the petition, has prayed for rejection of the plaint on the ground that this court has no territorial or pecuniary
2
jurisdiction
points I have taken,
to
my lord.
entertain and determine the suit as the plaintiff enhancing the valuation
Yes, my lord.
of the suit intentionally has attracted the jurisdiction. Yes.
My lord, I have taken 2 points, my lord. The first point was that the court doesn't have pecuniary jurisdiction because the tenant, the landlord has
Where is the
enhanced.
plaint? Where is the
My
plaint?
lord, page 19, my lord.
Yes.
As
What is
the
the suit property?
my lord, the suit property is one is the ground floor, that is the first unit, my lord, and the second is the mezzanine floor, that is the second unit.
In which area?
It is in Roland Road, my lord. He has referred in page number 39, showing it to be the one property only. Lordship may kindly come to page 100. There are two different agreements. One is of 1990. Page 100, my lord.
So what is wrong as regards to the
My lord, totally different property, totally different cause of action, totally different, distinct agreement has been made. One of 1990, one of 2020. And
learned counsel
Well,
in the impute go through the
page
second,
198.
fourth, fifth paragraph, first 2 lines.
Regarding
What is mentioned here? Place.
regarding valuation of the suit property, I have found, I have not,
Territorial and pecuniary jurisdiction.
I have-
Barring that, anything else?
my lord, I have filed this for that also, my lord. Territorial and pecuniary jurisdiction, my lord, according to,
Anything else?
yes, my lord.
Barring that?
Barring that, he is saying the other points will go before the it will be taken in the time of trial, my lord. As per the learned court, what learned court has said, my lord. So lordship may see,
Place the order. Place the order.
my lord. Today is fixed for further hearing of the petition dated so and so by the defendant.
From the 5th paragraph, defendant by filing the
Regarding
petition.
valuation of the suit property, I have not found any cogent reason to interfere that to attract the jurisdiction of the court. Plaintiff has valued the suit accordingly. Regarding the rest 2 allegation of the defendant challenging the validity of the plaint in view of Order 7 Rule 11 of the court, non-disclosure of cause of action, and defect in service of notice, I am inclined to hold that the plaintiff has disclosed sufficient reason to file the present suit against the defendant, and that the alleged defect in service of notice, being a triable issue, cannot be entertained at the stage to reject the plaint.
What is wrong?
My lord, according to me, the overvaluation which I was saying, my lord, pecuniary jurisdiction. My lord, may kindly see. Kindly give me 2 minutes, my lord. 2 minutes. The overvalue. He has rejected my point of overvaluation, my lord. Your lordship may kindly see the plain, my lord. The agreement says 250 rupees is the first agreement, first property, unit 1 is of rupees 250. And the lordship may kindly come to 100 once, my lord. Kindly come to 100, my lord. Page number 100. Point number 1, my lord. The tenant shall pay the rent of rupees 250 per month.
Which paragraph?
Page 100, my lord.
100.
Yes, my lord. That is the agreement.
Hmm.
Point number 1. The tenant shall pay a rent of rupees 250 per month to the landlord. And point number 4, that it is hereby expressly agreed that the landlord shall not entitled to and shall not claim any increase in the aforesaid monthly rent under any circumstances during the tenure of this lease agreement. So, admittedly, the first rent for this is for mezzanine floor, my lord. The lordship may kindly see the second para of this page, my lord. Whereas the landlord has agreed to let out and the tenant has agreed to accept tenancy in respect of mezzanine floor, consisting of one room, one
Which
toilet.
paragraph? Which paragraph are you facing?
Page 100, my lord, second para, my lord.
Hmm.
Whereas
Second
the
paragraph that the
landlord has agreed to let out and the tenant has agreed to accept the tenancy in respect of mezzanine flat consisting of one room, one toilet. So this was related to mezzanine floor, my lord. One room costing is 250 rupees per month tenancy, my lord. Lordship may kindly come to another agreement, page 105. Kindly see the second para, my lord. The landlord has agreed to let out the tenant and agreed to accept the rent in respect of ground floor flat. Page 100.
Can you go through the? Is the page 103 legible?
No, my lord, it's not.
Read out page 103.
It is little difficult to read out. It's not legible in my copy also. 105, my lord. If your lordship see, it's a ground floor property. Second para, and the rent is 1,250 rupees.
Yes.
At point number 1, the tenant shall pay a rent of 1,250 rupees. So if I calculate
So
the
what's
rent,
wrong in
my
the
lord, as per
valuation of
Premises
suit?
Tenancy Act, my lord, as per first of all, the suit has to be filed below the lowest court below as per section 15 of CPC. My lord, if your lordship, they have filed in the senior division. They have not filed before the municipal court, my lord. Secondly, even as per the West Bengal Premises Tenancy Act, if your lordship comes to the schedule 4, section 12A1, it says in any other suit to the Chief Judge of the Small Causes Court under the Presidency Small Causes Court Act in the town of Kolkata. The property is within the town of Kolkata. It was supposed to be filed at the lowest level court, my lord. If your lordship may kindly come section 15 of the CPC, my lord.
Not required.
They have filed in senior division. So that's why we were saying that they have overvalued the suit. They have taken the lease tenancy rent, additional tenancy rent. They have added the damages. They have added the means profit. And being a two separate property, two distinct property, they have suppressed those facts and purposely combined all so that the valuation of the suit can be increased.
What is the schedule in the plaint?
My lord, page. Lordship may come page 39, my lord. That only I am saying. They have combined both. I was showing you. They have combined the mezzanine floor as well as the ground floor, and enhanced the suit value, my lord.
Yes. They have sought for eviction in respect of both the ground floor and the mezzanine floor.
My lord, having a total separate agreement, total different. My lord, the suit value, if I consider 250 and 1250, my lord, the suit value has to be 1 year of the total. You also may kindly see once Court Fee Act, my lord. The suit value has to be 12 months rent.
Yes.
That comes to around 25,000 only. So if it is less than 60,000, my lord, it has to be filed in the lowest court below, my lord. Lordship may kindly see. Section 7. 13D, my lord. For the recovery of immovable property from the tenant, including a tenant holding over after the determination of a tenancy, the suit value has to be according to the amount of the rent of the immovable property to which the suit refers, payable for the year next before.
36,900.
So, my lord,
That comes to 36,900. Thereafter,
they have added damages and means
Yes.
profit, my lord. If I am a statutory tenant, my lord, means profit cannot be added in this way, my lord. I have a judgment to that effect also, my lord.
Learned Counsel, where is the mean profit? And for damages,
My lord,
valued at 57,000.
Admittedly, they have accepted that I have improvised the suit. How the question of damage doesn't come. Even if I consider only the suit value based on the 12 months rent, it cannot go above 25,000. And they have valued it more, my lord. Lordship, may kindly see the act, my lord. West Bengal Court Fee Act. 12 months rent can be taken for the valuation of suit value, my lord. They were present on the last occasion. Notice. I'm grateful, my lord. Now, may I only pray one more thing, my lord? Till that time, the matter is fixed for evidence in the court below, my lord.
Next.
Lordship, may kindly grant some.
No, next.
Grateful, my lord.
Item 30, your lordship granted.
Next.
My lord, 34. My lord, the council will join virtually.
You are for the petitioner.
I am
It was
for
my
the
application,
petitioner, my lord.
It was my application. Because defendant in a suit for declaration and injunction is the petitioner before your lordship due to a rejection of an application for rejection of plaint. Rejection was sought on 2 grounds. Rejection of plaint was sought on 2 grounds. Firstly, there was an earlier decree on compromise back in 1910, which does not give any cause of action to the plaintiffs.
Dated.
Sorry, I'm so sorry, Millets. Compromise decree dated.
No, not dated. Learned Counsel.
26 September 2024.
26 September 2024.
Yes, Millets.
At page 209, my lord.
You are the
I am the defendant in the suit and the petitioner before your lordship.
defendant, tenant.
No, Millets, this is not a case of tenancy.
For
This is a suit concerning a Devottar property for declaration and injunction.
title suit 51 of 2019.
Yes, Millets.
511, my lord.
Yes.
Millets, I will be very brief in my submission.
What was your prayer?
Millets, I sought rejection of plaint under Order 7, Rule 11.
On which ground?
2 grounds. Firstly, there was an earlier compromise decree
Where is the petition?
Because my application is at page 27. Because kindly have para 5.
Paragraph.
Because para 5 at page 28.
Yes. You place it?
Yes, Millets. Because that the real facts is that one such and such person established this temple in the year 1280 Bengali calendar. His son-in-law such and such inherited the Thakur Seva. That was the start of Mallik Thakurbadi. Sukumoy Mallik, youngest son of Jagodananda Mallik, created the said Devottar estate, namely Sri Sri Jagannath Jiu and Radhakanto Jiu.
What is the moot point?
Moot point is this issue which was raised in the plaint was already settled by a decree which was passed on compromise back in the year 1910. So, suit is hit by principles of res judicata. That is my first ground.
So why did you file Order 7 Rule 11? So
yes,
you file Order 7 Rule 11 instead of other provisions mentioned in the CPC?
Because of the second ground, that there was an earlier suit which was filed by the same set of plaintiffs in 1994, which stood dismissed for default under Order 9 Rule 8, against which restoration was not allowed. And this suit has been brought on the same cause of action, which is a clear bar established under Order 9 Rule 9. My lord, the earlier suit of 94 is at page 186. Kindly sees the memo of parties in the present plaint and at page 186. The memo of parties at
Page
page
180,
186.
page 184.
186. Title suit 219 of 1994.
First page of a title suit being 219 of 1994.
My lords, this was the earlier suit by the same parties which stood dismissed for default, the order of which is at page 202. Order date, kindly have 201 first, my lords. 201. I'm so sorry. 201. Order dated 23rd of June 1998.
Yes.
Kindly see that 202 suit was dismissed for default, not restored. So the two grounds in my order 7 rule 11 was firstly barred by res judicata. I would understand that point of res judicata cannot be agitated in an application under order 7 rule 11. But the bar under order 9 rule 9 is a clear bar under law, which bars a fresh suit on the same cause of action. Let's take it from me. Same party, same cause of action. If your lordships want, I can refer the plaints, both the plaints.
Issue notice.
Well, I would pray a stay on the further proceedings of the suit.
No. Issue notice.
So if suit progresses, my lord, then
Accordingly, you will have to take steps.
but now that this is pending, I cannot file an application under order 14 rule 2 there.
Next.
You kindly fixes a date, my lord, a short date, my lords, kindly.
2 weeks after vacation.
I'm so grateful, my lord.
I'm praying for not today, my.
Next.
Deeply obliged. 36.
Fine, sir, Devaraj.
37 to 39, I'm for the petitioner, my lords. I'm being led by Mr. Pinaki Mishra, senior advocate. He's appearing online.
May it please my lords, my lord. Am I audible, visible to my lord, my lord?
Yes, visible, audible, both.
I'm very grateful, my lord. This is a very, very short issue, my lord. We are not going to trouble your lordship too much. My lord, these are three connected matters. There was a fourth matter. My colleague who's in the court, my lord, if I may request your lordship to kindly give her the indulgence of handing over to your lordship. My lord, the order passed by my lord's predecessor court, my lord, Justice Hiranmaya Bhattacharya, my lord. This was an order of 28th of April. This is in the companion matter. There were four matters disposed of together by the State Commission and by the NCDRC also thereafter. We've come against the NCDRC in 227 before your lordship, my lord. In one of the matters which was listed, this is the order passed. If I may trouble your lordship, my lord, the second page or first page. Can I read the whole order, my lord? If your lordship, my lord is already reading the order.
Place it. Place it.
Please, my lord. This application under Article 227 is directed against an order dated 27th of December 24 passed by the learned NCDRC in first appeal. On a bare perusal of the said order, it appears it was passed by a sole non-judicial member of the commission. That's the short point, my lord. Learned counsel, my lord, representing the petitioner herein places reliance upon an order of the Honorable Supreme Court in, my lord, the case of Tiki-Taki Industries in support of his contention. The order passed by sole non-judicial member of the learned NCDRC is non-est in the eyes of law. Same is not permissible as the quorum cannot be treated to be complete. So, my lord, is quorum non-juris, my lord. On a query of the court, learned counsel appearing for the petitioner submits the hearing of the first appeal is adjourned till 9th July. There shall be an order of stay of all further proceedings in first appeal 351 pending before the learned NCDRC till the end of the month of June or until further orders, whichever is earlier.
Learned Counsel, this order has been passed on 28th of April 2025.
Extension.
Right, my lord. Right, my lord.
In the fag end of September 2025.
My lord, the matter hasn't come up thereafter. It's only now coming up.
I'm handing over the extension order, extension of interim order. It's
Yes.
valid till
So,
November.
What do you seek now?
My lord, I am seeking the same order in these three matters as this matter because they're all a common appeal.
No, Learned Counsel.
I'm sorry, my lord.
No. The impugned order is in which page?
My lord, your lordship will find, my lord, which matter is your lordship taken up, my lord, because there are three matters. My lord, is your lordship taking up 37, my lord?
CO nine-
Gautam Manna?
CO 980 of 2025.
That's right. That's Gautam Kumar, DLF versus Gautam Kumar Manna. My lord, your lordship will find the impugned order is at page, my lord, 28. And this is the matter, my lord, of Nisit Bariyar, the order I just read out to your lordship. NCDRC order. Your lordship will find in the impugned order, my lord.
Let me go through.
Just see the impugned order first, my lord. If your lordship don't mind, I'm so sorry.
Learned Counsel, let me go through the order which has been furnished to me, dated 28th of April 2025.
Right, my lord. That stay was extended.
You can page 20. That's in at 28, I mean.
How are they four? These are six names.
Since June 2025, what has happened?
My lord, thereafter, your lordship will find there's another order, my lord, extending this, and that your lordship will find is of 26th of June 25, which is, my lord, which my colleague will hand over to your lordship if your lordship don't mind, my lord. Affidavit of service filed in court today is taken on record. In spite of service, none appears to oppose the prayer for extension of interim order. The interim order passed on April 28th as extended till the date of month of November 25 is extended till the date of month of November 25 or until further orders, whichever is earlier. List this matter under the heading contested application, the monthly list of September. That's how it's coming up before my lords now, my lord. So up to November, it's already extended in one matter. The other three matters had not been tagged on. They are now listed before your lordship. And your lordship will find.
Why didn't you pray at that relevant point of time?
My lord, his lordship said, my lord, let the matters come up in due course. The same order will follow. I think without the matter being listed, the court didn't find it appropriate to, my lord, pass orders if the matter was not on board. That's the correct position, my lord.
Have you complied the third last paragraph of the order dated 28/4/2025?
My lord, the petitioner directed to serve a copy of the application upon the opposite party by registered post. Yes, my lord, your lordship will find the order dated 26th of June. My lord confirms that affidavit of service filed in court today is taken on record.
Paragraph.
First paragraph, the first line of 26 June 25.
In spite of service, none appears to oppose the.
That's right. That's right.
So, what is the prayer now?
My lord, your lordship will kindly see page 28 is the impugned order. These three matters listed now before your lordship are along with the fourth matter which was passed on that day. All four matters were disposed of by the same impugned order. Your lordship will find that at page 28. My lord, your lordship see first appeal number.
The first appeal number is same.
No, my lord. Your lordship will find first appeal number 351 of 2019, and then that is DLF versus Nisit Bariar, page 28.
Yes, Nisit Bariar, the CO 1114 of 2025 also in against Nisit Bariar.
No, my lord. Your lordship will find there are three other appeals. First appeal 822, first appeal 823, and first appeal 2071.
My lords, if I may, it's on page 28 itself, just before the cause title, just below the cause title, along with FA.
Before the name of the learned member, my lord, just above the name of the learned member.
Along with
FA 822 of 2019.
Yes,
That's right. That's right. These are the three first appeals now listed before your lordship. So these four were disposed of together.
So CO 980 arises out of which one?
My lord,
That's FA 2071 of 2019, the last one. The last one. 71 of 2019.
Where from?
My lords, along with, my lords, you see, along with, just below that, 822 of 2019. Oh.
In the petition, where
para 21.
Paragraph?
21. Page 9.
Place it.
My lords, thereafter, the petitioner filed a first appeal number 2071 of 2019 on 16th October 2019 before the learned NCDRC, challenging the order dated 7th August 2019 passed by the learned SCDRC West Bengal. One of the main issues raised in the first appeal was that the consumer complaint was ex facie barred by limitation. Copy of the first appeal is annexed as Annexure M. My lords, Annexure M is at page 255.
And CO, the other revisional applications are?
my lord, the others are FA 822 and FA 823.
No.
My lords, 822 of 2019 pertains to CO 981 of.
One by one. Actually, first name. CO 980 of 2025. An application under 7 of the Constitution of India being directed against an order dated 27/12/2024.
Yes, my lords.
27/12/2024 passed by the learned National Consumer Disputes Redressal Commission at New Delhi. In first appeal number 2071.
Yes, my lords. 2071 of 2019.
2019. 71 of 2019. Which has been heard and disposed of. Fight an order passed in first appeal 351 of 2019 along with first appeal FA 822 of 2019, comma FA 823 of 2019 ये number হলো প্রথম বলেছি 2071 2019 আর তারপর 351 2019 আর 822 2019 আর 823 2019 first paragraph. On perusal of the said on perusal of the impugned order dated 27/12/2024, it transpires that the said order has been passed by the administrative member by a sole judicial member passed by a sole non-judicial member of the commission. Paragraph. Where a senior counsel representing the petitioner submits that apart from this first appeal, 3 other appeals have been preferred in respect of the impugned order. Full stop. Said impugned order. Full stop. You are relying upon the same judgment.
That's right. Milord, 3 writs have been preferred, not appeals. You know, these are all writs before your lordship. I'm sorry. These are all
Appeal
writs.
appeal 3 appeals have been preferred. What else? Last paragraph. Writ applications have been preferred. Appeal. First appeal, if you are against that writ. Where is the authority which you are citing?
Milord, the authority I'm citing is with a list of judgments, Milord, I think which was given along with the compilation. This is Milord Tiki Tak Industries.
It is being provided just now.
I'm sorry, Milord. I thought we gave it to the learned court earlier also, Milord. But
the first one.
That's right. That's the first one, Milord. The judgment of Justice Hima Kohli and Justice Sandeep Mehta in the Supreme Court. If may,
Paragraph.
Straight away, para 3, Milord. At this stage, Mr. So-and-so, learned counsel appearing for the appellant, draws the attention of this court to the impugned judgment to urge that the same has been delivered by a sole non-judicial member of the NCDRC, which is not permissible as the quorum cannot be treated as complete. Submission made by counsel is borne out from the record. The impugned judgment has been passed by a single member of the tribunal and the quorum itself being incomplete. We are of the opinion the matter ought to be remanded back to the tribunal for a fresh decision. Needless to state, the records available for the tribunal shall be relied upon by both parties, so and so, Milord, and for a decision to be rendered by a bench comprised of a proper quorum. The impugned judgment is quashed, set aside. Parties to appeal for registrar, so and so, appeal is allowed, disposed of in the above terms. So, Milord, this was the judgment, and this is identical, Milord. Page 28, your lordship will find Learned Sri Rajendra, who's a single member, non-judicial, has passed this order, Milord.
I've gone through in last paragraph here. The learned senior counsel representing the petitioner submits from the this present writ application. Apart from this present writ application, 3 other writ applications have been preferred. Subparagraph. Out of the same, they are civil, the CO number 1114 of 2025. CO number 1114 of 2025 in respect of the first appeal number 351 of 2019. We are taking up 980. CO number 981 of
Hello.
2025.
First appeal 822 of 2019.
CO number 981 of 2025 is in respect of has been preferred assailing the order passed in FA
822. 822, my lord.
of 2019
That's right, my lord.
and CO 982 of 2025 has been preferred assailing the order passed in
59.
FA 823
Yes, madam.
823 of 2019. As তিনটে ফাইল আছে তো CO 981 আর CO 982 দেখে নিন ভালো করে আছে তো as all the three learned counsel,
Please, my lord.
you are submitting that it is a writ application.
That's right, my lord. There are writs under 227, my lord.
Civil division.
Huh?
They call it civil division.
I'm sorry, my lord. They call it civil revision, I'm told in the High Court, my lord.
Civil revision.
I'm sorry.
As all the three civil revisions have been preferred in respect of the self-same impugned order passed by the said commission dated 27/12/2024. So, three separate orders are required.
Yes, my
My
lord.
lord, I would think so, my lord, because each is a separate civil revision, my lord.
না না ওটা হবে যেটা আমি অ্যানালগাস করতে চাইছিলাম হ্যাঁ হ্যাঁ বাদ দিয়ে দিই The learned counsel refers to further submits that the impugned order has been passed by a non-judicial member of the said commission and refers to a judgment passed by the Honorable Apex Court in the case between Tikitar, TIKI, Tikitar Industries, now known as Tikitar Industries Baroda Limited versus National Insurance Company Limited. So, the impugned order is non-est in the eye of law. From the paragraph 3 of the said judgment referred to, which states as follows: বলে প্যারাগ্রাফ থিটা কোট করে দেবেন। It transpires that the Honorable Apex Court has been of the view that the quorum being incomplete, the matter is to be remanded back to the tribunal for a fresh decision. In such circumstance, paragraph, in such circumstance, there shall be yes. As regards to stay,
My lord, your lordship, see the other order passed as your lordship then pleases, my lord. There shall be an order of stay of all further proceedings in first appeal 351 pending before the so and so till the, my lord, till November, my lords have said, my lord. So your lordship could tag all the matters together if your lordship so please, or as your lordship's, my
when
lord.
you're saying so, when I had asked you, you were saying that no, all the three separately orders are to be passed.
My lord, orders may be passed separately because there are 4 different revision applications, my lord. That's the reason I requested your lordship to take the trouble of passing 4 different orders. But, my lord, the matters can be tagged together and heard together because the point of law is the same, my lord.
There shall be an order of stay of all further proceedings in the. There shall be an order of stay of all further proceedings in the first appeal number 351 of 2019 pending before the National Consumer Disputes Redressal Commission at New Delhi till the end of
Lord, 351 has already been passed. That is the other matter. These now will be
of November 2024 or until further order, whichever is earlier.
these will be, my lord, to 3 other matters, my lord. 2071, 822 and 823. 351 is already stayed.
Um, the petitioner, next paragraph, the petitioner is directed to serve a copy of this application upon the opposite party by registered post with AD and to file an affidavit of service revealing compliance of the same on the next date of hearing. Full stop, paragraph. Let the matter appear. Let the matter appear on after 2 weeks. Let the matter appear after 2 weeks of vacation, as per the convenience. 2 weeks of puja vacation, as per the convenience of the bench having the determination. Full stop. All parties to act on the server copy of this order duly downloaded from the official website of this court. Certified copy of this order, if applied for, shall be made available to the parties. Same order in respect of item number 38 and 39. Council through virtually. Through virtually or presence furnishes the compilation. Furnishes a compilation of judgments which we kept to the record. Next.
Very
Obliged.
grateful, my lords. Deeply grateful to your lordship, my lord.
Item number 40. 41. 41. 41.
Yes.
My application for amendment of the written statement. My application for amendment of the written statement has been turned down. I have come up, my lord, against that order, my lord. My lord,
At what stage it was
Right.
filed?
it was filed after the cross-examination of PW1. And my amendment relates to certain admissions,
What?
suit for eviction. My admission relates to,
In which page is the plaint?
yes, nice. Plaint is at page 10.
You are the tenant.
I am the tenant. My amendment relates
What
to
you-
certain,
What for?
yes, my amendment relates to certain admissions made during the cross-examination of PW1. My lord, may I say, my lord, the plaintiff was not the, my lord,
Have you furnished the application?
yes, page 41.
41.
Yes, my lord.
What is the
My lord,
proposed
page 42
amendment?
is the proposed amendment, my lord.
Place it.
Yes, my lord.
In short, not the entire history reproduced. In
But
short,
14J, my lord, the amendment short formula that at the time of cross-examination of the PW1, it is admitted that the suit property is consisting of two separate holdings, that is 97 Kalikundu Lane southern part and 97/1 Kalikundu Lane northern part. And the plaintiffs are the owner in respect of the holding number 97/1 Kalikundu Lane, and one Mitali Karar is the owner of holding number 97 Kalikundu Lane. That the plaintiff has filed the instant suit for eviction against the defendant in respect of the entire suit
what is
premises.
the relation between the plaintiff of 97/1 and the owner of 97?
Yes, Mitali Karar. Kindly see, there is a name, Mitali Karar. Mitali Karar was my inducting landlord. And at that time, the entire,
Presently the owner of 97.
yes, and at that time, the 97/1 was part of
Plaintiff has purchased from Mitali
a
Kara
portion of 97.
portion of 97.
Now, my lord,
which has been renumbered as 97/1.
yes. Now, my lord, I say that my suit property, my lord, falls both within 97 and 97/1. A portion is falling under the 97 and a portion is falling under the 97/1.
What is the extent of tenancy?
Not may I say.
Schedule in the plaint?
Yes, I'm just. It's the, my lord,
Page?
tile and 15, my lord. Though no measurement has given, my lord. 15.
1.5.
Yes. Partly tile and partly tin shed room. I'm carrying on business, my lord. Therefore.
Bedroom. Of holding number 97, now 97/1 Kalikundu Lane. Yes.
Yes. My lord, 97 is still there. A portion. My lord, at the time of admission, at the time of I'm sorry, my lord, at the time of cross-examination of PW1, it was admitted by the, my lord, plaintiff.
So from the
Yes, may I say.
evidence of
Yes.
PW1. Page
It's starting from, my lord, page 23.
22.
23, my lord, 23.
Specify the
Yes,
portion.
may I, my lord. ये कहाँ है देखो तो क्रॉस कहाँ पे क्रॉस क्रॉस my lord, I did not. Where is the cross? Chief, my lord, I have annexed, my lord. My cross, my lord, I have obtained certified copy, but somehow it's missing from the brief, my lord. My lord. Yes, my lord, kindly takes up page 26 once. My lord.
Where from the cross-examination commences? Where from
The cross-examination, my lord, I could not annex, my lord. At that time, my lord, I did not had. I obtained a certified copy, but my lord, somehow I find that that's not in the brief, my lord. I have obtained it. At the time of filing, it was not there, but I have obtained it later. But my lord, it,
then
may I try my luck tomorrow? Kindly.
no, the record is to be complete.
But one thing would be evident from the order that while rejecting my application, my lord, the court has, my lord, given two grounds. One, my lord, the
record has to be complete. Otherwise, how can the court go through?
but
I mean, the learned counsel
may
representing
the
the petitioner submits that you take steps to complete the record.
instead of that, my lord,
Huh?
instead of that, my lord, to produce certified copy of the cross examination.
Take steps accordingly and praise for.
I have one, my lord. Kindly allow me to come
Accordingly,
tomorrow.
prayer is considered and allowed. Let steps be taken in a week. Within a week after the
But-
Puja vacation, let the matter appear before the appropriate bench, having the determination as per the convenience of the.
Allow me to try my luck tomorrow, my lord. I have obtained, my lord.
Next.
Great.
Number 42.
My lord, in item number 42, I am the applicant, my lord, and the plaintiff, who is a landlord, and this is a suit for eviction, my lord. And it is very painful, my lord, where every court has held that the tenants are illegally occupying my premises.
You are the
I am the landlord.
landlord.
Yes, my lord. My lord, I am challenging the order, if I may point out before your lordship.
Impugned order.
Yes, my lord.
Page.
My lord, 1 minute. My lord, page annexer H, page 93.
Impugned order.
Yes, my lord.
Place it.
Yes, my lord. On the contrary, by filing the written objection, plaintiffs denied all the material allegations of the defendant and prayed for rejection of the instant petition. Petition is the defendant's.
Commences from which page?
My lord, page 93. And 93, there should be another page.
Is it complete?
No, my lord, 94 should be first, then 93. Somehow it is, wrongly annexed. I tender my apology, my lord. It begins from 94, my lord, page 94. Today is
Let
fixed.
me correlate.
Yes, yes.
Are very much intelligent. Order 7, Rule 14.
Yes, my lord.
No. On consent of both sides, the case record is taken up for hearing the two petitions under under section 7, subsection clause C of Presumption of Persistency Act. By objection,
To be more specific, the impugned order is, my lord, at page 99. There is a clear copy. Page 98, 99. Those are typed copies.
Where is the certified copy?
The certified copy. It is filed probably, my lord.
Which page?
Certified copy too.
Same order as the earlier one.
My lord, may I file the certified copy?
Same order as the earlier one.
My lord, only one indulgence. My lord, may I file the certified copy? Everything is on record, my lord.
File.
I am giving an undertaking, my lord.
Within a week from after the Puja vacation.
Very well, my lord.
Next.
I'm grateful.
Number 43.
43.
43 and
Next.
44.
But I am for the my lord petitioner, my lord. In petitioner, my lord, opposite party, in the my lord original suit for partition, my lord, filed by the opposite party, my lord, in the year 1996. And my lord, preliminary degree passed in the year 2007. And my lord, no amicable settlement. Then my lord,
Since 2007.
my lord,
Since 2007. No amicable settlement.
2007, no settlement. 2010, 8, my lord, the petitioner, my lord, filed an application for final degree, appointment of survey commissioner. And my lord, the opposite party, my lord, filed an application under order 47, rule 1, read with 151 for my lord staying the degree. And but my lord not taken any step. He has not served.
Get Order 47, rule 1.
My lord.
That is
For my lord not implement the degree or my lord stay the degree.
Order 47, rule 1.
My lord.
What is it?
My lord, actually, my lord, in the order sheet,
To be filed within?
my lord, actually, my lord, filed within my lord 90 days, but my lord, they have filed my lord after lapse of 2 years. But my lord, not taken any steps. He merely filed.
47.
My lord.
Order 47, rule 1.
Application for review of the judgment.
To be filed within 30 days. 30 days.
My lord.
Not 90 days.
30 days, my lord. But my lord, he filed after lapse of 1 year. But my lord, merely only filing of the application, not my lord served any copy, nothing else. In spite of repeated direction of the learned court, finding no other alternative, learned court fixed the main suit for argument.
Review of which order? Review of
my lord the degree of preliminary degree. And my lord, direct
preliminary degree.
My lord.
Passed in the year
2007.
Where is the application?
That application is not me, my lord, but my lord, page 4, my lord, para 7, my lord, I have specifically stated on the details that the plaintiff opposite party filed an application.
It has to be supported by document, learned counsel.
Under order 47, rule 1, read with 151 of the Code of Civil Procedure, supported by an affidavit bearing Misc case number 47 of 2010 on 15.
Now, what is the impugned order and where is it?
My lord,
certified copy of the impugned order.
My lord, last order, my lord, fixed for my lord argument, but because of pendency of the
Where is the certified copy of the impugned order?
My lord, that is my lord, this application is for my lord expeditious disposal of the Misc case. My lord, as because my lord, pendency of this Misc case.
Where is the certified copy of the impugned order?
Certified copy, my lord, I have annexed, my lord, in my application, my lord, since
where it is?
2014 to my lord 2024. My lord, date fixed for argument, fixed for argument.
Where is the certified copy of the impugned order in the record?
I have no impugned order, my lord. I have, my lord, only prayed for expeditious disposal of the Misc case.
Where is the last order?
Last order is, my lord, last order, certified copy last. Order number 154. 2nd December 2023. Today is fixed for acceptance of focus. My lord. Last certified copy, last page, my lord.
Order number 51.
54, my lord, 154.
Order number?
154, my lord.
Where is the order?
My lord, in my my lord, that is my lord, page 14, my lord, the type copy. And my lord, certified
not-
copy,
I'm not asking the typed copy. Certified copy.
certified copy, that is my lord,
Yes,
Last
place it.
my lord. My lord, in type copy, my lord, today it fixed for acceptance of so-called both party file Hajira, hard learned advocate for the petitioner, consider so-called petition is accepted to date fixed for hearing of the petition 12/5/2022. That is petition
3rd of
for
August. 3rd of August. That is the
my
date
lord,
has
that is
passed
my
by.
lord, still pending, my lord.
That has passed by. Where from this court will know that no order has been passed on 3rd of August.
My lord, this is my lord, my application, my lord, filed in the year 2024. And my lord,
What is the next date?
next date, my lord, I do not know at this stage, but your lordship kindly direct where my lord some date, my lord, specified, but not from the next date. My lord.
The record is not complete. You
My lord,
have got for an order. You have filed the divisional application seeking expeditious hearing.
disposal of the Misc case. My lord, kindly, my lord,
Yes.
direct
Yes.
to dispose the Misc
Counsel.
case from the, my lord, specified date from the next date. Your lordship kindly do this. This suit is pending, my lord, since 1996. My lord.
Anything more to be submitted?
My lord,
Anything more to be submitted?
so, my lord, I have, my lord, only praying before your lordship.
From the last order, it is revealing that the next date was fixed on 3rd of August 2024. 3rd of August 2024 has passed by. Not only passed by, one year, more than 1 year has passed by. So how could this court know, bench know that what has happened since 3rd of August 2024?
That's why, my lord, I am praying, my lord, that, my lord, the date, my lord, if my your lordship pleasures that to dispose of the Misc
No
case,
order can be passed in this one.
then, my lord, I will suffer, my lord, the petitioner will suffer.
From
My lord, this is, my lord, my 2024 application.
You will
And, my lord, it is, my lord, unfortunate that, my lord, one expeditious disposal matter, my lord,
understand.
my lord.
The date was fixed on 3rd of August.
That is, my lord, I accept. But, my lord, my prayer is your lordship kindly direct the court below to dispose of the Misc case from some day within the date from the next date.
Have you proved it? That till date it is pending.
Yes, my lord.
Where from the record?
My lord, this is, my lord, my submission, my instruction, my lord. You
prove it.
Otherwise, my lord, I will not place the case before your lordship. I will, my lord, merely withdraw. If, my lord, that is not pending, then, my lord, I prayed before your lordship that for withdrawal.
Counsel, that you will have to do. Otherwise, no order can be passed.
My lord, my lord,
enough to understand.
My lord, that is, my lord, your lordship kindly consider only that this suit is 1996 and I am praying order from the date of next date of hearing. Nothing else. Your lordship kindly fixed any date.
According to this record which has been placed before this bench, the next date of hearing is 3rd of August 2000.
It was 2024. That time, my lord, this application was not disposed. But, my lord, my instruction is case is fixed and my prayer is.
We cannot go by the instruction of the client.
Well, then, my lord, your lordship pardon. But, my lord, humble prayer before your lordship.
Copy of the order sheet.
It will be, my lord, take, my lord, another 1 year.
It transpires that the last order was dated 2nd of December 2023, whereby The matter was fixed, the Misc case 47 of 2010 was fixed on 3rd of August 2024. Since then, no further order has been placed before this court. As such, this court is unable to find as to whether the said Misc case is still pending or has been disposed of. In such situation, the order could be passed as no order as per the prayer made by the petitioner could be passed. The present petition application is dismissed. Next.
My lord,
Next.
may I just indicate one thing? My lord, yesterday's list, my lord, after item number 45 and 44 and 45 today, my lord, my matter should have come. But my lord, they have somehow or the other appearing as 1 and 2. In normal course today could have been taken up. My lord, will kindly indicate, my lord.
Next.
My lord, then what will happen to 1 and 2? May I ask this question to myself, my lord? My lord, then we'll kindly adjourn the matter after vacation. Item 1 and 2, my lord, will kindly adjourn the matter after vacation, my lord. I'm praying that much only.
My lord, on behalf of the petitioner, I'm praying for not today, my lord. Kindly make it after
the
vacation.
opposite party, my lord, petitioner enjoying the stay order, my lord. The matter is pending for a long. It's a 2G matter, and they have filed an application under section 771 application.
My lord, she's.
It was for under section 2G of the West Bengal. Yes, and they have filed an application that was turned down by the learned court. Lordship,
Who was the original tenant?
the deceased, the mother of the petitioner was the original tenant who died long before. Now we have filed a suit for eviction.
Property, Learned Counsel.
My lord,
And
my
then
senior is
after obtaining the
having.
stay order.
You are receiving mean profit.
No, my lord, nothing.
Lordship, she's
Matter is
suffering
pending
from
for
fever.
due to
Kindly make it
heart, my
after
lord.
vacation.
Learned Advocate on record.
Yes, my lord.
She is submitting that the Learned Advocate on record is suffering from fever.
Now she is submitting. Now she is submitting, my lord. So, my lord, kindly fix the date, my lord. Maybe immediately after vacation, because this is
Not this. Next.
Lordship, the next matter is the same. The
matter.
petitioner is only different, but the suit is the same, my lord.
What can be done?
Lord, is it
My
after?
lord, we are suffering, my lord. Landlord is suffering, and getting nothing, but the matter is pending.
Same. Not this week.
After vacation.
And the Learned Counsels. Learned Counsel. Miss now, Miss Learned Advocate representing the petitioner submits that the Learned Advocate on record is ill. As such, he has sought for accommodation. Full stop. In such circumstance, let the matter appear after the puja vacation. 1 week after the puja vacation. Both the matters. Same order in both the matters.
Item number 50, my lord, I am led by Mr. Kostabachi in this matter. My lord, due to some personal difficulty, he has left the court, my lord.
Next. Replay.
My lord, in this matter, I am attending for the petitioner. There is Caddy. So, your lordship direct me to serve notice. Matter will appear after the vaccine.
So, the issue is
petition on
The issue.
caveat is there.
What is the
Preemption,
issue? Preemption. You have sought for preemption.
Yes.
On which
No,
ground?
but preemption, I preempted my lord. I lost before the trial court. Thereafter, when I heard an appeal, second appeal, I first appeal. Thereafter lost, then I had appeal to see the constitution. The other side was lodged the appeal. So, matter was
The Lord Counsel representing the petitioner or petitioners?
petitioner, petitioner plaint.
Petitioner. Why petitioner? Devashish Vishwas and another.
Other landowner.
Petitioners. Submit that. Caveat has been lodged when?
They have lodged.
When?
The order is there, my lord.
When the caveat has been lodged?
In the file, my lord, has been, they appeared before the Honorable Justice.
What a submission, Learned Counsel. Court will have to go through
What
the
is
file.
there,
Yes, everything will be there. What is the nothing to be further stated? Submits that caveat has been lodged by the opposite party. In such circumstance, let notice be served upon the opposite parties. Let the matter appear after a week after your vacation. Before the get bail, which will have to be terminated as per the convenience of the said bench. Next.
Siddhartha Lai is appearing for this matter in this matter. So he is code number 1. Paying for not
Next.
Item number 52 for the petition, my lord, I am led by Mr. Shah in this matter. He is asking for taking it as government matter. Then the matter come up after vacation. We have served.
No,
next matter. If my lord may permit, maybe file the affidavit of service matter.
Next.
Not 57 is my application for expeditious disposal of the matrimonial suit. The suit has been filed in the year 2021 and subsequently in 2023 a section 24 application has been.
Parallel hearing cannot be done in this bench.
Section 24 application has been filed. Basically, the wife is now staying in USA, and this suit has been filed by my client as the husband. That has been paid. Special marriage, section 20, not section 37 of the Special Marriage Act. Now the date fixed on 29th November 2025 for order in respect of the said Misc case.
Just after the vacation.
But suit has not been proceeded due to the pendency of that suit. Only by my prayer is not only prayer is that directed to the learned trial court to dispose of the suit within a time frame by your lordship.
Can it be done?
Why not?
Why not?
Lordship has
After the
ample.
order passed by Honorable Apex Court, Learned Counsel cannot be done. And in addition to that, the next date is fixed on
29th November.
according to you.
Yes, 29th November is the next date for
November.
Suit.
Learned Counsel.
2021 issue.
Yes.
framing of issue, then file this application and automatically that from the PH board to the shifted to the.
No direction can be given before to the trial court to dispose of within a specified time. And in addition to that, the next date is fixed on 29th November, just after the vacation. What to be done?
Well, disposed of pass the necessary order. Unnecessary, that is pending. There is no purpose.
The learned counsel presenting the petitioner. Petitioner, wife,
Husband.
The husband submits that a matrimonial suit is pending before the additional district judge, 5th court, Alipur,
Alipur, yes.
wherein a Misc case has been filed.
My Misc case has been filed. This is my
This case has been filed
page 37.
being Misc case number 87 of 2020.
On a fifth additional district judge.
Additional district judge, 5th court.
5th court. 87 of 2023.
2023. Under this case is
Under section 37 of the Special Marriage Act.
section 37
1954.
From where is the last order?
The last order is page 93. Learned advocate both side file Hajira. Learned PO is transferred. Learned PO is in charge is busy with the own file. Page 93.
Page 93.
Yes.
What is the last order?
Order number 33 dated 14th May 2024.
Place it.
The learned advocate
No, last line.
On 26 July 2024 for hearing Misc case and filing documents, if any, in the meantime. Well, after 1 year, that hearing is concluded.
Wherefrom this court will know that whether that miscellaneous application or petition filed therein, whatever may be, is pending or not.
For my, I will submit before your lordship.
Yes, there shall have to be some document. There shall have to be some document.
The learned advocate appearing before your lordship and stating the inter alia that the
26/7/2024.
According to the instruction, 29/11/2025 is the date fixed for order in the Misc case.
He further submits that the next date fixed in the said Misc case is 29th November 2025. No. As the matter is fixed for passing order just on 29th November. So, review that no order as regards to early disposal is required. The said petition is disposed of.
And as disposal of the expeditiously, that word may be incorporated.
Would have been passed if there had been the last order.
Grateful, your lords.
Your lordship, my application There was an order passed on 8th of January 2025, the last order, and the relevant portion is at paragraph 8.
This for
Lordship, it was an application for preemption. There were two applications simultaneously filed. Now, keeping the application of the petitioner pending, the application which was filed thereafter by the defendant, that was proceeded with. Considering the same, Your Lordship, the relevant paragraphs in the order of 8 January is paragraph 2.
the impugned order.
Lordship, it is order dated 13th May 2024. Since the matter has come up, Your Lordship, today, I am apologetic because I am without the brief, Your Lordship. The Lordship, I have the order copy, Your Lordship. I'll be humbly praying, Your Lordship, there was an interim order which was granted, which is at paragraph 8 of the order.
13th of April 2022.
13th of May 2024. Don't touch it. Lordship, page 23 of the civil, the revisional application. Page 23.
It contains the prayer portion.
Lordship, I'm sure, referring to the order.
Where is the certified copy of the order?
Lordship, it is annexed here.
Which page?
Lordship. Page 132.
May 2024.
24, Lordship. Lordship, it was considered and accordingly.
Petition dated 26th of February 2024 filed by the petitioners under Order 1 Rule 10(2) of the CPC is hereby rejected. You had sought for?
Yes.
Addition of parties?
Lordship.
Whom you intended to add?
Lordship, it is the suit wherein we are praying for preemption in respect of the particular premises, with regard to which, Your Lordship, the defendants also have subsequently filed a preemption application. That was proceeded with without hearing me. One of the parties was also a party in the previous suit. That is my suit. Now, Your Lordship, I'm not entering into the entire facts, Your Lordship. Now, what has happened?
Even my lord, they have alternative
obtained
DVD
that-
and they have also.
They have obtained an ex parte order. To that application, I had prayed for an addition of party that was turned down. Subsequently, this present civil divisional application has been filed.
As I can get, there are two suits.
Lordship.
One filed by your client and the other filed by their client.
Lordship.
The suit filed by their client is an earlier one.
My lord.
No,
My lord.
it's the later one. Later one.
No, my lord.
ठीक है बोल।
Suit filed by.
According to you, the suit filed by your client is the earlier one.
The earlier one, which was kept pending.
Wherefore we'll get.
Lordship, in that event, may I humbly pray your Lordship, since I'm without the brief to have just taken it from my learned friend. Lordship, only not today, your Lordship, because Lordship, I'll be praying since the matter has come up, your Lordship. We had mentioned it on many occasions. The Misc case, the misappeal 28 of 2024 shall also remain stayed. This interim order, which is at paragraph 8, your Lordship, I'll be praying for some extension. Some extension, your Lordship. Lordship, till the after vacation, your Lordship.
My lord.
Lordship, kindly.
Let the matter appear within a week after the vacation. After a week, just after the puja vacation.
Lordship may very kindly grants a date in that event, any date.
It cannot be granted by this bench because it will be taken up by the bench which will have the determination at that relevant point.
Oh, Lordship, we were under the impression that the matters were assigned before this honorable court. Lordship, then in that event, your Lordship,
So till tomorrow,
Lordship,
not assigned.
Lordship, in that event, your Lordship, since I'm praying for an
Let the matter appear
Lordship, since an
after
an interim protection is already granted, your Lordship. It is not that, your Lordship.
To be extended, my lord, because what happened, they by showing that, my lord, they are taking regularly adjournment in the trial court, my lord.
Lordship, it has been stayed considering the matter on merit. Lordship, it is not that I am without any protection from this honorable court.
I won't be able to hear both of you.
I'm sorry, my lord.
Lordship, kindly hears me, your Lordship. On this point, your Lordship, Lordship,
The matter has come up today.
Lordship,
The matter has come up today
Lordship,
for hearing.
Lordship.
It could not be taken up because of some reason.
Lordship, then I'll do the matter, your Lordship. Then I'll do the matter, your Lordship. This interim order, I'm praying for an extension.
Apart from that,
Lordship, I'll be only praying for an extension. Your Lordship will be, anyway, your Lordship might be directing.
let the matter appear after a week.
Great.
Either the matter can be heard of or it will appear after a week.
Lordship,
Extension has been also stayed.
Lordship, I am praying for hearing of the matter only
It has lapsed on
March 2025. Lordship.
Learned counsel representing the petitioner seeks an accommodation. Let the matter appear. Application as per the convenience of the bench, having a determination at that point of time.
Grateful, my lord.
Number 60.
My lord, I appear for the port trust, my lord. Yes, my lord, respondent. Now, this was filed in October 24. No steps have been taken. Yes, my lord, I'm for the port trust.
Seems to be from the first list.
I'm the respondent number 2.
While you respond, that is
My lord, Shama Prasad Mukherjee Port, Kolkata. My lord is not dismissing it. My lord, after the vacation, after the vacation.
3 days at this present moment.
Grateful.
61.
62 is my application, my lord. My lord, that I am the defendant, my lord, in a suit. Suit has been set. Suit for, my lord, declaration injunction. Suit has been settled between the parties. The dispute has been settled. Order 23, Rule 3 application filed. Section 151 filed. A letter given to the registry because those two were pending for almost.
Suit is pending before.
The suit, my lord, is pending before, my lord, Bidhan Nagar, Junior Civil Judge, Junior Division, Bidhan Nagar.
23 read with section 151.
Not read. Order 23, Rule 3 filed first back in, my lord, April 2024. Nothing happens. The court grants nothing. We will cannot get the matter heard. Subsequently, nothing happens, man. We appear, our next date is written. After 6 months, my lord, we file another petition 151 so that it can be taken up and, my lord, the matter can be disposed of. My lord, to get the suit dismissed. To get the suit dismissed because the deed has already been.
Be kind enough to sit it there.
My lord, the suit to be taken up, dismissed because the dispute has been settled, a deed has been executed between the plaintiff and the defendant. My lord, what I pray now, my lord? My lord, what I pray now, my lord, is there are a series of matters filed of this sort, my lord, because more than 2 years these matters were pending, my lord. A coordinate bench, my lord, has directed the matters to be remitted back to Bidhan Nagar Court, my lord, with a direction to get it heard out, the pending applications heard and to dismiss the suit in a time-bound manner. May I hand over a copy of the order, my lord. Passed by, my lord, a coordinate bench. My lord, these are, my lord, 3 cases which came up from Bidhan Nagar Court before this court. My lord, involving, my lord, more or less the same parties. My lord, kindly goes to, my lord, this will, my lord, I am praying, my lord, that the suit be remitted back. This matter, my lord, be remitted back with a time-bound direction upon the court to dispose of the applications.
Where is the last order?
My lord, in such a case, my lord. My lord, may I pray for one indulgence, my lord? My lord, kindly makes it not today, my lord. Let us come back after the vacation. Not this week. That's okay.
Next.
Okay.
Sixty-nine. 70. 71. 72. 73. 74. 75. 76.
My lord, learned advocate Suprabhat Bhattacharya appear on behalf of the petitioner. He has not come to the court and he due to illness and so kindly make it after vacation.
77. 78. 79. 82.
My lord,
Item number.
my lord, item number 81. My lord, item number 81, suit for specific suit for under section 6 of the specific relief act, my lord. And I am appearing for the defendant petitioner. The plaintiff filed a suit under section 6 of the specific relief act, and I filed an application under order 7 rule 11 of the code of civil procedure, and that was dismissed. Against this, I prefer provisional application, my lord. The suit is, the ground is, the suit is barred by limitation, my lord. Kindly see page 17. It is barred by limitation, my lord. Kindly see, according to section 6 of the specific relief act, no suit under this section shall be brought after the expiry of 6 months from the date of disposition. My lord, 17, kindly see page 17. My lord, there is no caveat, my lord.
Page 17.
Page 17, my lord. বেদখল অত্র নালিশের কারণে এলাকাধীন সাবেক কাকদ্বীপ আল নামখানা থানার অন্তর্গত মৌজা পাতিবুনিয়া গ্রামে বেদখল করিবার তারিখ বিগত 4 বৈশাখ, মানে দ্যাট ইজ 18/4/2021 এবং ভয় প্রদর্শন ও শাসাসনের তারিখ 7/10/2021. That is after 6 months he filed this application, this suit. And not only that, my lord, I am paying regular taxes, panchayat taxes there, and suppressing that fact, he filed this application, filed this suit. My lord, therefore, I filed application under order 7 rule 11. My lord, there is no caveat, my lord. May I serve the copy?
Let notice be served upon the respondent or respondents.
Upon the respondent number 1 to 8.
All the respondents.
All the respondents, my lord. My lord, my lord, my lord. After, my lord,
Weeks of the vacation.
sir, after, my lord, 2 weeks.
Yes.
After 2 weeks, acha, 2 weeks after vacation. My lord, grateful, my lord, grateful to your lordship.
'83, '84, '85, '86.
86, man.
86, my lord. I am appearing for the petitioner, my lord.
Lord, I'm for the opposite party, my lord.
Representing
My lord, may I submit?
representing
Petitioner.
Petitioner wife, my lord.
Wife.
Yes, my lord. My lord, in this case, my lord, the opposite party husband, my lord, filed an application for, my lord, custody of the child, my lord, under section 17 and 25 of the Guardian and Wards Act, my lord. My lord, in the, yes, my lord.
Child is aged.
5 years.
Yes, my lord.
Child is aged.
5 years.
5 years.
5 years. My lord, the minor son, 5 years. My lord, the petitioner filed an application for visitation right, my lord. My lord, after, my lord, considering, my lord, the application, the learned judge, my lord, passed an order. Your lordship, kindly directly see the order, my lord, page 45. No, my lord, page 59, my lord. It starts from page 59, annexure E.
Order number
And my lord,
order
yes, order dated 7th September 2024, order number 13. Now, your lordship, my lord, I am reading the relevant portion. Yes.
The ordering portion.
Yes, my lord. Page 61, my lord.
Yes.
That the visitation petition dated 7th March 2023 filed on behalf of the petitioner father Shukanto Das under section 12 of the Guardian and Wards Act is allowed on contest and the same is disposed of. Thereafter, my lord, the petitioner father Shukanto Das is permitted to visit his minor son Shukanto Das on the first and third Saturday of every month for at least 2 hours from 2 p.m. to 4 p.m. in the premises of the learned advocate of the petitioner situated at first floor, Mukherjee Apartment, KK Mitra Road, pin code 700125, in presence of the mother of the minor child or any other representative of the opposite party mother. Then, my lord, both the parties should ensure that their conduct and behavior in front of the minor child should be such as that no unreason.
Learned counsel.
Yes, my lord. My
Yes.
lord, your lordship, kindly consider, my lord, one
One minute.
submission.
1 minute, learned counsel. Do you have any
Yes.
submission? These basic things are to be kept in mind. Otherwise, the respect of the institution will be at stake. Sorry to say from this end. Yes, so 1 minute, learned counsel.
Yes, my lord. My lord, then next paragraph, my lord, both
One
the
minute,
parties.
1 minute. So,
Yes.
father was allowed to see his son on the first and third of Saturday of every month.
Yes.
In between 2 p.m. and 4 p.m.
At 4 p.m.
in the chamber
premises. Yes.
of his learned
Learned advocate.
Yes.
Learned advocate of the, my lord, the opposite party husband, my lord.
Yes.
My lord, I have, my lord, no objection regarding the visitation of the child by the minor child by the father.
1 minute, learned counsel. This
Yes.
is order dated
7th September 2024.
7th September. So 1 year has passed by.
Yes, my lord. But immediately I have filed the revisional application, my lord. That was appearing in the list, my lord, monthly list. My lord, I have tried to get it hard, my lord, but
Well, this is on consent order.
1 minute, learned counsel.
The word consent was pronounced as contest. Kindly come to the
my lord,
operating first paragraph.
my lord, your lordship kindly allow me to submit, my lord. My lord, I have
Everybody will be allowed. Everybody will be allowed.
Yes,
let the court have the clear vision.
Let the impugn order, started reading my learned friend, paragraph 10, that the visitation petition dated.
Place the paragraph 10.
Yes.
Again, slowly.
That the visitation petition dated 17th March 2023 filed on behalf of the petitioner father Shukanto Das under section 12 of the Guardian and Wards Act is allowed on contest and the same is disposed
allowed
of.
on
Contest, my lord, I appeared, my lord.
Learned
My lord,
counsel, learned counsel, one thing. Can you say this thing on affidavit? Can you say this thing on affidavit?
My lord, that I appeared.
Can you say this thing on affidavit?
That is allowed on contest and the same is disposed of. My lord, I have no objection regarding visitation. Only, my lord, the place of visitation. Your lordship kindly see paragraph 12.
Wait a minute. Wait a minute. You go through paragraph 10 and thereafter you apprise your senior.
It's consent.
Apprise your senior.
Consent লেখা আছে। that the visitation petition dated 17th of March 2023 filed on behalf of the petitioner Father Sukanto Das under Section 12 of the Guardians and Wards Act is allowed on consent and the same is disposed of.
Could you hear it?
Yes, my lord, I have seen, my lord. Your lordship kindly consider, my lord. My lord, at the date of hearing, my lord, the petitioner, the opposition party husband made an application, my lord, regarding the yes.
First of all, can you prefer a revisional application in respect of an order which has been passed on consent?
My lord, your lordship kindly consider, my lord.
Can you?
My lord, it has been stated, my lord, that it is allowed on contest, but your lordship kindly consider the yes, my lord. My lord, I admit your lordship's views, my lord, but your lordship kindly consider, my lord. One application has been filed, my lord. Your lordship kindly consider that application was not served, my lord. In that application, the place of visit was mentioned, my lord.
Not allowing
My lord,
No, Learned Counsel. First of all, let us settle this issue.
paragraph
Mentioned in the third line of paragraph 10.
yes.
First of all, let it be settled. Exactly which word has been mentioned in the third line of the said paragraph, number 10.
On consent.
Then, can you prefer a revisional application?
My lord, your lordship kindly consider, my lord. My lord, your lordship, my lord, has the, my lord, ample
revisional application in respect of an order which has been passed on consent.
My lord, your lordship kindly consider, my lord.
Yes. No. Huh?
But somehow
Ask your senior to switch on. Yes.
My lord. My lord.
Can you prefer a revisional application in respect of an order which has been passed on consent?
My lord, your lordship kindly consider, my lord, the situation, my lord. My lord, your lordship, my lord, has the ample jurisdiction, my lord, to modify the order, my lord. Your lordship kindly consider, my lord, one application filed before the learned court below, my lord.
Learned Counsel.
Yes, my lord.
If an order has been passed on consent, then there is neither any scope nor any opportunity to modify the said order.
Your lordship, my lord, I understand, my lord, your lordship views, my lord, but your lordship kindly consider situation, my lord. A 5 years old minor son, my lord, the husband resides in Domdom area, the wife resides in Domdom area, but the chamber of the learned advocate of the husband is situated at Barashat, my lord, that is far away from Domdom, my lord. On the date of hearing, my lord, my lord, the application filed by the husband indicating the place of, my lord, the visit. My lord, it was, yes, my lord.
What you are submitting,
yes,
if that had been the actual position, then
yes, my lord.
There are other provisions laid down in the Code of Civil Procedure,
yes, my lord.
908, which your client would have preferred.
May I submit?
Nothing has been preferred in that respect. So let this code be clear. This application cannot be entertained.
As your lordship, my lord, in that case, my lord, liberty may be given, my lord, to file an application, my lord, before the learned court below, my lord, for modification of that order, my lord.
1 year, on 1 year, they have
My lord,
not
your
reduced
lordship,
file.
my lord,
Only
since, my
because
lord, I have preferred the civil revisional application, my lord, and it is pending, my lord, since
is
24.
showing this
Your lordship
pendency 1
kindly, my
year.
lord, leave
Now,
may be,
what they are
liberty may be
suggesting, my
given,
lord.
my lord, to file an application before the learned court below for modification of that order, my lord.
What they are suggesting? What is the change of place?
My lord, I have no, my lord, I have no objection regarding the visitation right of the father, my lord. My lord, only objection regarding the place of visit, my
What
lord.
the place they are suggesting? I am agreeable. I want to see my son.
My lord, I have stated in paragraph 12, my lord, of my application, my lord. My lord, any park or public place, my lord.
একটু শুনুন কি বলছে।
Yes, my lord.
Council,
Yes.
in respect of this order dated
7th September 2024.
7th September 2024, this court, under the divisional jurisdiction, cannot
ma'am.
pass any other alternative order.
My lord, only my lord, liberty, my lord. Only, my lord, one sentence, my lord, liberty to file an application for modification.
I have a
before
strong
the
addition.
learned court, my
Because
lord.
again,
Learned Council,
On that portion.
Council, liberty cannot be expressed to this order which is being passed. It is up to the persons contending to take steps. Please. The Learned Council appearing virtually submit that the mother, namely mother, what is the name of the mother?
Srijoni Naha.
Srijoni Naha,
Srijoni
Naha. Yes, my lord.
Naha,
the petitioner.
Naha,
SREEJANI, alias Dash.
Srijoni Naha, has no objection. As regards to has no objection. Virtual has no
My lord, I cannot, my lord, I cannot hear your lordship, my lord.
একবার on করুন। Your representative here, your representative here.
Yes, my lord.
He is able to hear you. He is able to hear. So
My lord, if your lordship, my lord, allow me, my lord, to hear the order portion, my lord.
namely Shukanto Das.
Shukanto Das.
Yes, Shukanto Das.
But has difficulty as regard to the distance and the place of visitation. Full stop. Heard the Learned Council on perusal of the impugned order being impugned order dated 7/9/2024, passed in Misc case within bracket Act 8 number 63 of 2023. It transpires that said order has been passed on consent. Full stop. Paragraph as the order has been passed on consent. So this court is not inclined to interfere with the said order. Such revision or application is disposed of being dismissed.
My lord, the can is also, there is also,
My lord, your lordship.
you have filed a can for appropriate order, that is also disposed of.
As the revision application has been disposed of, so any application, any other application filed in respect of the said revision application are deemed to be disposed of.
Great.
My lord, one submission, my lord, your lordship, kindly, my lord, give a liberty, my lord, to file an application for modification, my lord.
Yes, I have expressed. If
Yes.
you are unable to.
My lord, the parties
Yes,
are
yes.
expected to act on the basis of server code. Because, my lord,
The parties are directed to act on the
because 8 is the date.
server copy.
I'm grateful.
Grateful to your lordship.